will be the truth, the whole truth, and nothing but the truth, Mr. Davis
Yes.
and Ms. Parker.
Yes, ma'am.
You may both lower your hands. And Mr. Nutt, you may proceed.
Well,
Okay.
one moment, please, before Mr. Nutt proceeds. May I just respectfully request some requests real quick? Because last time we were here on May 22nd, I let Mr. Logan speak, and I feel like that y'all kind of railroaded me because I'm not really up to date with the legal jargon and what to say and what not to say to get my point across. So I was just wondering if I could tell y'all something before, like, if I could speak freely. Can I speak freely?
You can speak freely when it's your turn to speak. Yes, ma'am. But right now it's Mr. Nutt's turn to speak.
Yes, ma'am.
Okay. All right. Go ahead, Mr. Nutt.
Okay, Judge. So you may remember this case. This is the one where the state had filed to essentially confirm arrears and modify, with the intent being that we were going to release the arrears on the case because our understanding was that the parties were residing together and stop the support obligation. After we filed that suit, I think Mom had filed a number of additional motions, including a motion to transfer, some claims against basically trying to attack an old order or collaterally attack an old order. I think she's filed numerous documents and claims since the AG's office initiated its suit. And last time we were here, I pointed out to the court that they had not served the grandmother on the case. I think it was the grandmother on the case, which she was involved in the order they're trying to overturn from 2017. So we were kind of stuck. The state is still ready to proceed with confirming the arrears at zero and stopping the support obligation if the parties want to do that. But as far as Mom's claims, the transfer, her attack of the order, everything else she's got pending before the court, I do believe that those require service on that third party, and I don't see that that's been completed.
All right, guys, buckle up, because this hearing wastes no time turning tense. The judge opens with routine swearing in, but immediately the mother disrupts the flow, pressing to speak freely before it is even her turn. You can feel the conflict brewing as she insists the last hearing left her unheard and overwhelmed. The judge shuts her down quickly, reinforcing order and signaling that this courtroom will not bend. Even in these first seconds, the clash between procedure and emotion is unmistakable.
Okay. And Ms. Parker, it is your turn to speak freely.
Thank you so much, Your Honor. First, I respectfully request referral of this matter to the elected district judge under Texas Family Code 201.015 because these motions involve constitutional and federal issues. Second, I object to this case continuing in front of an associate judge. I do not consent to these proceedings, and I preserve my right to file written objections within 3 days. Third, I object to jurisdiction. I reside in Collin County, not Dallas County, and this case was improperly venued. I also object to the continued enforcement of this case because it was initiated through fraud and misrepresentation by a third party, Lizette Shante Wilson, who had no legal authority. Fourth, the Office of the Attorney General does not represent me, my husband, or my child. They represent only the state of Texas, and I'm not voluntarily participating in their Title 4D services. I have a pending federal lawsuit addressing these same issues, and I want the record clear that I'm not waiving any rights by being present here today. And fifth, the child support portal incorrectly states that LaParis Davis was served on June 13, 2025. He was never served. And at the same time, Lizette Shante Wilson, the person the court previously said needed to be served, is not even listed on today's docket.
All right, guys, now the real clash begins. The mother unleashes a rapid-fire list of objections, attacking jurisdiction, venue, prior orders, and even accusing the process of being fueled by fraud. She challenges the authority of the associate judge, invokes constitutional claims, and insists she never consented to any of this. Every sentence escalates the tension as she argues that the wrong people were served, the right people were ignored, and the entire system is misrepresenting her case. This is the moment where her frustration, distrust, and determination collide head-on with courtroom structure.
This highlights that the wrong parties are being brought in while the real fraudster is being shielded. And for all of these reasons, I object to the associate judge proceeding further in this matter, and I request referral to the elected district judge, and I preserve all of my rights and federal claims. And that's all.
Mr. Nutt, your response?
Judge, at this point, I mean, if she wants it, my concern is that we're not moving anywhere because she's got a service issue that has not been resolved since the last hearing. And I think last time I pointed out that I just didn't want the case to end up going to district court and having the same issue of just kind of sitting there because she's not gotten service. That being said, like, I have no objection. If she wants it to go to district court, it makes no difference to me. So if the court is inclined to refer it, then, I will not object to that.
Ms. Parker, we can proceed one or two different ways. Mr. Nutt is prepared to take Mr. Davis's child support to zero. He's prepared to release all of the arrears.
It's already been that way, Your Honor. In that last
Well,
court.
evidently it's not, because Mr. Nutt is saying now that there are arrears on the case. And if there are arrears on the case, until they've been taken, till there's been a $0 judgment.
All right, guys, now watch how the atmosphere shifts as the state responds calmly but firmly. The attorney points out that no progress can be made because the mother still hasn't completed essential service, meaning the case is frozen by her own filings. The judge steps in, laying out two clear paths: proceed now and eliminate arrears, or send everything to district court. But even that comes with a warning: nothing will move until proper service is done. It's a moment where legal reality pushes back against emotional resistance.
It is still accruing interest, so it's still accumulating. But if you don't want to do it that way, we can refer this to district court. You're still going to have to get the third party served, okay? But if what you want is to refer this to district court, Mr. Nutt has no objection, and I have no objection. So just let me know what you want to do.
We would like to refer to a district judge.
Okay, then that's fine. We don't have to talk about it anymore.
But you had respectfully, you had stated the last time, Your Honor, that that's what needed to happen, because you said that you were unable to rule on any of the motions, and y'all also stated that.
You're right, but we still needed to get the third party served. So the same thing is going to happen up there. That's going to happen down here. It's going to sit until that third party is served with all of your documents. And so I was just trying to keep it down here so we could keep a hold on it, keep getting it set, so to make sure that it didn't fall through the cracks. But if you are asking that it be referred, ma'am, we can refer it.
Yes.
Okay. So, Mr. Nutt, will you get me an order referring this? What court is this out of? 303rd? That's Judge Atkins. Can you get me a referral order, sir?
Yes, I will get you a referral order.
Okay, then this case will be referred to district court. All other hearings will be handled in the district court.
Thank you, Judge.
You're welcome. If there's nothing further, thank you all for appearing here today, and you're free to go.
Jacob Referral.
All right, guys, here's the turning point. After all the objections and legal arguments, the mother finally declares she wants the case referred to a district judge. The judge reminds her that the same service issue will follow her no matter where the case goes. Still, she insists, and the judge agrees to issue a referral order. What you're seeing here is the system giving her exactly what she requested, while still emphasizing that procedure cannot be bypassed. It's a decisive moment where the case changes direction entirely.
And Mr. Guerrero, did you also receive an email with the petition that was filed in your case today?
Yes.
And do you understand you have a right to be personally served with that petition?
Yes.
Are you in agreement to waive personal service and to accept it through your email?
Yes.
And do you understand that because you were served today, you had the right to request a reset for your answer time to pass?
Yes.
Are you in agreement to waive your answer period and proceed with an order today?
Yes.
I'll pass the witness, Judge, and ask that the record reflect that Mr. Guerrero has agreed to waive service.
The record will also reflect.
Thank you, Judge. We're here on an order to establish the parent-child relationship. We have an agreement as to all terms. If I could read those terms and then take testimony.
You may.
Judge, so there's one child before the court. Parties agreed to establish Mr. Guerrero as the legal and biological father of the child Theodore Winborn. Parties are in agreement that his surname would remain the same. It's Guerrero-Winborn. Parties are in agreement to be appointed as joint managing conservators of the child. with the mother having the exclusive right to determine the residence in Dallas or any contiguous counties.
All right, guys, now the courtroom pivots into a completely different matter. The judge turns to Mr. Guerrero, confirming whether he received today's petition by email and whether he is willing to waive personal service. He agrees without hesitation, also waiving the usual answer period so the hearing can continue immediately. It's a stark contrast to the previous conflict, smooth, cooperative, and efficient. This short exchange highlights how quickly courtroom tempo can shift depending on the parties involved.
Currently, parties do have a visitation schedule that's working for them. They do understand and agree to the standard visitation schedule attached to the order. The father has medical and dental insurance for the child through his employer. Parties agreed child support would be $724 a month beginning September 1st, 2025. There's no retroactive child support, medical support, or dental support. Court costs would be as billed to Mr. Guerrero, and neither party is requesting any non-disclosures, and that is the extent of the order, Judge.
And child support is set at guidelines?
Yes, Judge, it's 20%, $724.
Okay, thank you. You may call your first witness.
I'll recall the mother. Ma'am, did you hear the terms of the order that were just stated to the court?
Yes.
And did you understand all of those terms?
Yes.
Are you in agreement with the terms and believe they're in the best interest of your child?
Yes.
Do you have any safety concerns as far as your address and contact information being listed in today's court order?
No.
I'll pass
I
the
have a request. We had like a monthly thing. I do know that it's like state guidelines that they have to do, like with the it's just I didn't come for more money, and I don't want him to think that I wanted like more money or anything like that. So if we could keep it at like the 500 a month, that would be great. But if not, like I said, he already agreed to it and stuff. So I was just trying to do that as like a request thingy.
Okay, so you understand based on guidelines,
Mhm.
his child support would be $724 a month.
Mhm.
But you're stating that he currently pays you $500 a month,
Yeah.
and you're wanting him to be ordered to pay the $500 instead of the $724?
Yeah, if that's possible, just because, like I said, we talked about it. We have like a good communication, and I don't want him to think that I'm coming here just to get more money, which I don't want. And he pays for other stuff, like he pays for all like the bills and stuff, and we don't have that. So I don't want him to be paying more money for him if he can have it and just be with the kid whenever he has it or whenever the baby, is over there. So I'd really appreciate if we can just keep it, because there's, like I said, there's other things that he pays for the baby. He never asked me to like pay for like any of the bills that come after insurance, so I would really like that to just stay the 500 if it's possible.
All right, guys, this final stretch is where everything settles into place. The court reads the full agreement: legal paternity, visitation terms, joint conservatorship, insurance responsibilities, and a guideline child support amount of $724. The mother then makes an unexpected emotional request to keep payments at $500, stressing she isn't here for more money. The judge holds firm but offers options, reminding her she can always return the difference. What follows is relief, closure, and two parents finally reaching stable ground after a long, tense process.
Okay.
Okay. Yeah. I was
Okay.
like, does that make sense?
I'll pass the witness, Judge, if I could recall the father.
You may.
Did you hear the terms of the order, Mr. Guerrero, that were stated to the court?
Yeah.
And did you understand all those terms that were stated?
Yes.
Are you in agreement with all the terms and believe they're in the best interest of your child?
Yes.
Do you have any safety concerns with your contact information being listed in today's court order?
No.
I'll pass the witness, Judge.
Then I will accept the agreement of the parties, make this agreement the order of the court. Child support will be set at $724 per month. Ms. Winborn, if you don't need the extra money, you can give it back to him. You can put it in a savings account for your child, or you can start helping him pay some of those bills.
I know. That's why I told him. I was like, I really don't. He knows like my family wise, and I don't want to be taking him to court. Like I said, we've reached an agreement, and I'm so happy that we're finally there at that point. So I was
Right.
like, I don't want to take you to court for money. I promise.
Okay. All right. Is
Thank
there anything further?
No, that's it.
All right, then thank you both for appearing here today, and you're both free to go.
Thank you.